Justice Alito?
Most of the most commonly used illegal drugs either had not been invented at the time of the adoption of the Second Amendment or the adoption of the 14th Amendment. Heroin was invented in 1874, cocaine, 1855, methamphetamine, 1893, fentanyl, 1959. Marijuana existed, but my understanding, hemp was grown for industrial purposes. My understanding is that it was not consumed to any degree by people in the United States until at least the beginning of the 20th century. Is that consistent with your understanding of the situation?
That is correct.
So we don't know what the founders, what those who adopted the First Amendment or, the Second Amendment or the 14th Amendment thought about illegal drug use per se.
Correct.
There's a lot of talk about alcohol. Do you think that the regulation of alcohol is exactly the same as the regulation of illegal drugs? Doesn't it have a different place in the history and culture of the West? Aren't there a lot of people who consume alcohol in moderation and have done so for centuries primarily for purposes other than the effect that it has on one's brain?
Absolutely, and I think that's why the post-ratification history is so difficult for respondent here with respect to the difference between illegal drugs and the history of alcohol use in moderation.
Now, as to Justice Barrett's question about Ambien, which I think is quite important, do you think that as a practical matter it is feasible for there to be as-applied challenges to the use of every drug on the schedule?
No, and I think Chief Judge Colleton's recent dissent in Lavina illustrates a lot of these problems in terms of how do you know exactly how much someone's taking? If it's an illegal drug, what's in it? How do you know exactly what the concentration is? What else are they mixing with other things? At what point do you might have a tipping point situation where someone goes into a greater risk of addiction or having additional mind-altering effects? These are really hard judgments, and those are the kind of judgments that go into scheduling determinations.
922G sets out a whole list of categories of people who Congress presumably thought created a special danger with regard to the possession of drugs. Do you see a ground on which one might say an individualized determination is required for G3 but not for any of the other categories in G?
I think that would be difficult, and if you did so, you'd be taking down G2, which is particularly hard to fathom. That's fugitives. So I don't know how someone would say, how dangerous is this particular fugitive in the moment? Like, did they just get scared? What's going on? Or other parts of G4, and then there's a lot of issues with respect to G1, but I think we could all agree it would be passing strange to suggest that it's constitutionally required for serial murderers to be subject to individualized dangerousness determinations for Second Amendment purposes.
Thank you.